Well, hello and welcome back to my channel. My name is Joanne. I'm a law student from Australia. How are you going? My background and my camera and everything's going a bit funny today, so I'm in and out. I'm in and I'm out. I'm up and I'm down. Anyway, hello, Plan to Create. How are you? So we have some new filings that have hit the court. So she has filed her motion as expected. I believe there was 30 days for that to occur. We have got a motion, we have got a memorandum, and we have got an affidavit from the lawyer. So we're going to have a quick look at all of that and see how we go. So let me just put this up. So just so that you can see, we have on the 15th of the 8th. So yes, it's taken a few days to get up. So it may have been there before, but look, I'm a bit slow. I haven't really been checking. We've got a notice of motion, a memorandum, and an affidavit. So let's look at the notice of motion first. Okay, you are reading this the same time as I am, so you are going to get my live reactions. So you are going to get my initial reactions and my first reaction, because I haven't read this before. So we are going to do this together. So it says that it's a notice of motion and motion to reconsider. To plaintiffs and their attorneys, take note that pursuant to court's order dated July 18, 2025, and without a hearing, Minnesota defendants Katie Joy Mansky Paulson and without a Crystal Ball LLC will bring the following motion for hearing before the Honourable Kari Willis, Judge of District Court. Defendants do hereby move the court for an order reconsidering the court's order dated June 23, 2025, pursuant to Minnesota General Practice 115.11, and granting defendants' motion for summary judgment. Insofar there are no material issues in dispute, and defendants are entitled to judgment and as a matter of law on all issues. And that is signed by the lawyer. Okay. The other thing I wanted to just check before we go any further. So they've now filed the official motion. Yes, here we go. This is what I wanted to see. So I wanted to see, so it's cost her $100 for this motion. So we've got here that on the 18th of the 8th, 2025, there was a charge made and a payment received. So there's the receipt for it. See that? So she paid $100 for this motion. Okay, so they filed the motion. So with that, they need to have a document that states out their position. Now, this is 23 pages long. So this is going to be very interesting. So this is a memorandum of law in support of its motion to reconsider the court's decision. So now we're going to go through some of the arguments that they put in the letter. Now, don't forget that the other party now will have in the orders, it was stipulated how many days they had to give their response. So there'll be a response that will be coming. Okay. Now, so this is going to be interesting. So the preliminary statement. So the motion for reconsideration is not about reweighing evidence. It is about the court's constitutional duty to decide as a matter of law whether plaintiff's claims may proceed at all. Controlling precedent requires dismissal now, not trial. On June 23, 2025, the court granted in part and denied in part defendants' motion for summary judgment, leaving certain defamation-based claims, a tortious interference claim, and a statutory negligence per se claim for trial. When public figure plaintiffs challenge speech on matters of public concern, the First Amendment requires court to act as gatekeepers, resolving 3 threshold questions before trial. Facts versus opinion. Are the challenge statements provided factual assertions or protected expressions of opinion, rhetorical hyperbole, or subjective interpretation? implication. Does any alleged implication convey a probable false factual meaning as opposed to mere insinuation or interpretation by the audience? Actual malice. Is there a clear and convincing evidence that the defendant subjectively knew a statement was false or seriously doubted its truth at the time of publication? These are not discretionary steps. They are constitutional prerequisites designed to prevent litigation itself from chilling core speech. That's a very interesting. I would never ever have worded that sentence that way. From chilling core speech. What do you think about that sentence? It's a very interesting. Chilling core speech. What a phrase, hey? These are not discretionary. They are constitutional prerequisites designed to prevent litigation from chilling core speech. Here, plaintiffs concede they are limited purpose public figures, and the speech at issue addresses matters of public concern. The only constitutionally permissible standard is New York Times actual malice standard, and the record contains no evidence of actual malice. Isn't that why the judge wanted it to go to trial, so that the court could decide? Anyway, for these reasons, plaintiff's interference claim cannot survive because it is based entirely on the same protected advocacy. Their negligence per se theory under Minnesota Statute 609.765 fails under Turner, and even if it were not, is inconsistent with application of the actual malice standard. And even if the court were to disagree on the merits, plaintiff's failure to comply with the court's damages discovery order provides an independent ground for dismissal or substantial narrowing of claims. At the very least, the court should resolve the discovery discrepancy now, so that at the time of trial, defendants will have the information necessary to mount a defense. So it looks like they are still talking about discovery issues, which we have looked at the documentation and we have seen what was and not available for discovery, because she's still going on about, or she has still been going on about, the fact she's not been able to see their financial records. It was only 7M's financial records that were needed to be discovered. Anyway, so it says facts, and there's a thing here. It says facts. Defendants do not submit any additional facts in support of this motion, but ask the court to refer to material submitted in connection with the party's summary judgment motion. So this is interesting, okay, because they are not wanting to rely on any new evidence, but everything already submitted into the court. Now, we don't know what they've necessarily submitted, but so they can't rely on the rates. They can't rely on the fact that they can't rely on any of that stuff, because they're already asking the court to rely on everything that's already been submitted. And their summary judgment motion was filed before any of that other stuff. So when she's going on about all this new evidence that they've got, they're actually not asking the court to look at any of that. So, which is a very interesting point. So you've got to you again have to bear that in mind. They're only wanting to rely on evidence already before the court. The core facts of this case provide crucial context. Hi, Harrison. Crucial context for constitutional and procedural issues now before the court. What began as a routine commentary by a digital journalist. Now she's a digital journalist, escalating to high-stakes litigation aimed at silencing criticism. The background is not merely atmospheric. It underscores that the plaintiff's theory of liability seeks to criminalize lawful expressive conduct. I thought she was a reporter that reported facts. Now we've changed the playing field. We're saying it's a routine commentary. She's a digital journalist now. The lawsuit arises from widespread public concern about the activities of 7M Films and Shekinah Church. Hang on a minute. We've now mentioned the church. The church is not a party. Now, you can't just throw in Shekinah Church now when they're not a party to the litigation, both of which have become subject of online and mainstream media coverage in 2022. Paulson, who spent years reporting on influencer culture, celebrities, and cults, turned her attention to 7M after receiving information about a video posted by Miranda Derrick's family that expressed concerns about Miss Derrick's participation with 7M Films and Robert Shin. Her reporting included on legal filings, interviews with whistleblowers, and analysis of public social media content. These were fringe allegations. Her coverage intersected with news reports, litigation, and high-profile exits from the group. Most recently, now, here we go. Now, after saying we're not going to rely on any new evidence, they've chucked this in. Most recently, on July 25, was the location of a raid pursuant to the federal search warrant, reported on charges which would be relevant to the issues raised in the lawsuit. More declaration. Defendants have requested copies of this search warrant but have not received any response from plaintiffs. As a result, defendants may soon need to bring a motion to secure additional discovery related to this raid. So it comes down to, are the raids related to this lawsuit? So it's interesting that they've said here, defendants do not submit any additional facts in support of this motion, but ask the court to refer to materials submitted in connection to the matters. And then they've brought in the raids. Are they wanting to bring in new evidence, or are they wanting to rely on previous evidence? As Paulson's reporting gained traction, plaintiffs filed suit in Wright County alleging various tort claims. The complaint characterizes Paulson's speech as defamatory, harassing, and intentionally destructive. But rather than identifying probable false factual claims, it primarily objected to Paulson's tone, conclusions, and rhetorical framing. Notably, the plaintiff's own public presence contributed to the robust public discourse they now claim were injurious. At summary judgment, this court properly dismissed several claims related to statements that plaintiffs could not produce, but left others for trial, citing possible implications of defamation and malice. In doing so, however, the order did not expressly apply the established doctrinal tests. It did not reach the threshold legal question of whether the challenge statements are opinion or fact. It did not. I thought she did. I thought she had said that the hashtags came across as fact, or gave the illusion as fact. Anyway, I thought there was those I thought the judge had made those statements in the judgment. But anyway, so this is their argument. This is what they're saying. It did not analyze whether the undisputed record could support a finding of actual malice. I thought it did. It did not address the constitutional process afforded to Paulson's boycott advocacy. I thought it did. These are not peripheral matters. They are central to the First Amendment's protection of speech on issues of public concern, and they go to the heart of whether these claims can proceed at all. The failure to resolve them at summary judgment departs from the controlling law and prolongs litigation that burdens the constitutional rights of Paulson and every citizen who engages in vigorous public debate. The procedural history compounds the problem. From the outset, the parties had been mired in discovery disputes. Paulson sought documents substantiating plaintiffs' allegations of reputational and financial harm. On January 29, 2024, this court ordered plaintiffs produce damages related to discovery. This production never occurred. However, plaintiffs continue to claim entitlement to a multi-million-dollar recovery. At summary judgment, defendants asked the court to address these deficiencies, which go directly to the plaintiff's ability to prove essential elements of their claim. In their notice of motion and motion, defendants expressly requested the exclusion of damages evidence. The court instead directed defendants to bring yet another motion, which would mark a fourth attempt to obtain compliance. So this is the statement of issues presented. The challenge statements are non-actionable opinion, rhetorical hyperbole, or subjective interpretation of disclosed facts. The alleged implications are not provably false. Plaintiffs have not shown actual malice by clear and convincing evidence. The tortious interference claim fails as a matter of law because Paulson's advocacy was constitutionally justified. The negligence per se claims under Turner and the First Amendment. Plaintiffs' failure to comply with court's January 24, 2024 discovery warrant sanctions. The court must determine as a matter of law whether Paulson's statements are actionable fact or protected opinion. This case does not hinge on whether Paulson's commentary was flattering. It hinges on whether it was actionable. Under Minnesota law, the question is not left to the jury. It is one the court must decide, legal standard. Whether a statement is fact or opinion is a threshold legal determination. In McKee versus Lorien, they're quoting this case. To make this determination, the court must apply a 4-factor test: the precision and specificity of the statement, whether it is objectively verifiable, its social and literary context, and the broader public context in which it was made. So there's some more cases here. Fine versus Bernstein, Milkovich versus Lorraine Journal Co., Hunter versus Coughlin. The test formulation comes with required gatekeeping questions that identify as a matter of law whether a statement is actionable. The first factor, precision and specificity, asks the court to determine whether a statement is precise and specific enough to warrant a factual assertion. Vague or general statements are more likely to be seen as opinions. So here's my question. When she accuses Shin of some of those of trafficking and waterboarding, are they vague or general statements, or are they factual based or precise, specific enough to be interpreted as a factual assertion? That's the first test it's got to get through. You can make up your own mind as to whether some of her statements have been opinion or fact. It is my view that she's walked a very fine line, and they could be, some of her opinions could be interpreted as fact. Okay. The second factor, verifiability, is if a statement can be objectively proven true or false. Hang on. I've just got to take a phone call. Just give me a minute. Oh, sorry about that. My mother just rang me because she saw something on the news about something. So that's all right. All right. So second is verifiability. It is more likely to be considered a statement of fact, while statements that are inherently subjective or incapable of verification are generally protected opinions. Okay. The third factor asks the court to consider the social literary context of the statement, whether a statement is made in the context of an editorial, a heated debate, or a satirical opinion impacts on whether an audience would interpret it as factual assertion or opinion. All right. So here's the thing. If you have a whole pile of people then saying that they are going to write to somebody or other or write complaints, then are they making that based on opinion, or are they making that because they interpret it as fact? That's where I say that is verifiable. The fourth factor asks the court to consider the greater public context of the statement. Statements made in political campaign or on social media may be more likely to be interpreted as opinion or hyperbole. interesting. Minnesota courts apply the test holistically, considering all 4 factors rather than in isolation. Okay. And it says challenge statements specific and verifiably, as well as the literary and public context of factors used by courts in distinguishing between fact and opinion. Expressions of opinion, rhetorical and figurative language are generally not actionable if, in context, the audience would not understand them as factual representations. So here's the question. Do you think the reader would take it as would think of it as her opinion or as fact? And that's what it comes down to. And I think seeing some of the responses to some of those posts, that some of the people have considered it as fact. That is my interpretation and my view. Okay, this is my opinion. Okay, application to the record. To illustrate how this 4-factor test is applied to the current case, defendants break down more than 80 statements alleged in the complaint to 6 categories. Statements relating to plaintiff's participation in assault, statement characterizing conduct by 7M and SHIN as human trafficking, statements alleging financial exploitation and dishonesty, statement alleging coercive control, statements summarizing lawsuits and public records, and sarcastic and hashtag-driven commentary. She's not going to say that she was being sarcastic, was she? Without a crystal ball, YouTube videos, which are often cross-posted to Instagram, start with an intro that establishes that Paulson attempts to be topical, funny, intelligent, and that she delivers tea. I love that. I love attempts to be. All right. So anyway, let me read that. Let's be serious again, okay? Without a crystal ball, YouTube videos, which are often cross-posted on Instagram, start with an intro that establishes that Paulson attempts to be topical, funny, intelligent, and she delivers tea. WOACB's Instagram page characterizes Miss Paulson as a digital creator, independent journalist, and mummy sleuth. Paulson's content is about social media influencers, the entertainment industry, and cults. Her audience is looking for tea and commentary, but Paulson maintains that her reporting is fully grounded in fact, and her opinions are clearly labelled as such. And she's not reading the news, and her audience does not expect WOACB to be neutral clearinghouse for wire stories. This is interesting. That line there, very, very interesting. She maintains that her reporting is fully grounded in fact, and any of her opinions are clearly labelled as such. So my question is, why is she trying to argue that a lot of these statements are opinion when she's admitted in this own filing that her reporting is grounded in fact? Hi, Mama Kay. So we've got a statement where she said she's not relying on any new evidence, and then she puts a thing to say that she's relying on new evidence with the SHIN's raids. Then she's saying that her that she's not a news channel, but that her reporting is fully grounded in facts, and her opinions are clearly labelled, but that most of her statements about 7M have been opinions. We've got contradictions galore in this, and we're on to page 7 of 23. Finally, many of the stories featured on WOACB are not clean, fact-driven stories. Hang on a minute. But she says, Paulson maintains that her reporting is fully grounded in fact. Then here, many of the stories are not clean, fact-driven stories. I'm gonna have to take something after this, Nurofen or Panadol or something, because this is just giving me a headache. WIOACB covers stories that feature people who are giving their version of events and may present a biased or incomplete picture of what actually occurred. Yeah, well, it'd be all right if you told people that. But anyway, no reasonable audience member. I have a feeling she's going to get away with it again. I hope Todd Chrisley goes for her breach of settlement, says plan to create. Now, yeah, that's interesting. I mean, talk about confusion. This is so confusing. No reasonable audience member would conclude from Paulson's reporting that there aren't other perspectives that may alter their understanding of events. What? In fact, Paulson's reporting does include statements from plaintiffs, even if she overlays those statements with her own commentary. Where reporting was both positive and negative, context of such statements was sufficient for court to conclude statements were protected opinion. So I would like to see somebody point out to me a post that Katie Joy has made where she has actually stated that she's only got one side of the story and that there's two sides to the story. I'm waiting for that. The context is equally important to the inquiry as to whether the statement identified in the complaint a fact or opinion, as an analysis as to whether the statements are precise or specific or objectively provable. To illustrate how the court's legal... So now we're going to tell the court how they should be analysing stuff. Who wrote this? Because this is bizarre. To illustrate how the court's legal analysis must operate in practice, consider the following representative examples drawn from a summary table attached as Appendix A. This is a cult. Statements about whether an organisation is a cult cannot be objectively verified. In fact, plaintiffs have cited no case where any such statement was deemed actionable. For that matter, plaintiff's deposition clearly acknowledges that whether an organisation is a cult is not cut and dried. She could not provide a definition of a cult. Ms. Derrick stated that a cult is a culture, and then that Ms. Derrick stated that cult is a culture. Huh? Why did they write that twice? In Dunn versus National Beverage Corp, the court stated only statements that present or implied existence of fact can be proven true or false, are actionable under state defamation law. Interpretations, theories, and conjectures are not actionable. In Dunn, the court was considering whether it was defamatory to question whether the plaintiff was an authorised distributor of the defendant's products. The court found that the particular statement was susceptible to a determination whether it was objectively true. This case is illustrative of the distinction between verifiable fact and opinion. It is possible to determine whether a beverage seller has the right to distribute a product. Whether an organisation is a cult is open to a number of answers. This is trafficking. Plaintiffs object to Paulson's use of trafficking as defamatory, but this word, absent, is literal claim of criminal conviction. What? I heard her big mouth going on. She was stating this mess as fact. I think, KJ. Well, as I said, Mama, Kate, there are contradictory statements everywhere. I mean, this sentence doesn't make any sense. Plaintiffs object to Paulson's use of trafficking as defamatory, but this word, absent a literal claim of criminal conviction, is used to describe perceived coercion, isolation, or grooming. Here, Paulson's commentary arose in the context of a discussion about 7M dancers being cut off from their families. She did not accuse anyone of committing a federal offence. Rather, she used expressive language to characterise a pattern she deemed exploitative. So why didn't she use the word exploitative? In a live video published on March 1, 2022, Paulson addressed the issue of human trafficking during her discussion of Lydia Chung's lawsuit between Mr. Shin and the Shekinah Church and other entities controlled by Mr. Shin. After discussing the fact the case was resolved publicly, possibly through a settlement, Paulson stated that Kelly Wilkin was concerned that her daughter was not paid. She further indicated that she was told by a choreographer friend of Aubrey Fisher that he was watched constantly while on set and was not permitted to talk to anyone on set. That's interesting because when you're on set, you generally can't talk. You can talk to other people on set, but you can't really talk. You know, you can't be taking phone calls and stuff. But anyway, Paulson indicated that if Chung's allegations were true, that would constitute human trafficking. Paulson cited a definition listed by the United States Department of Justice, which states that human trafficking, also known as trafficking in persons, is a crime that involves compelling or coercing a person to provide labor services to engage in commercial acts. Paulson Post clearly states that she's not using the word human trafficking to refer to forced labor. In context of Ms. Paulson's reporting, the term human trafficking is used in the context of statements that might be verifiable facts, but the characterization of those facts as a leading to a conclusion that human trafficking is occurring is not in itself verifiable. But why use it if you can't verify it? And the other thing is, how does it explain her hashtags, human trafficking? In Hunter versus Coughlin, the Court of Appeals considered a number of allegations that are very similar to the ones made here. The court determined that even though the statements asserted opinions that the plaintiffs had engaged in criminal behaviour, they were couched in such a way that the average person would construe them as lay opinion. These statements include the following. These include the allegations that Coughlin said, "I hope Mr. Hunter does time as he deserves to do time." Randolph said, "This is BS" at the end of Hunter's trial for theft by swindle, and Randolph said prior to and after all three trials, words to the effect that anyone who was favourable to Mr. Hunter must have been paid off. These similar statements are very similar to those made by Paulson's. Paulson's commentary was grounded in the practical definition of human trafficking, but it was still opinion. Oh, interesting. So tell me, what are you thinking about this? This issue was presented head on in Art of Living Found versus Doe's 1-10. She's back trying to rewrite history. It's a KJK way. So then here is this is from a case here. Certain statements are obviously critical and do use words like embezzle, fraud, and abuse. For example, these are statements that they obtained money from participants on false, deceitful declarations. Company individuals gave money to AOL organization for specific projects, but the money never reached those projects. None of this money goes towards helping any of the poor, disadvantaged people. And if you want to launder your black money, then AOL is for you. Plaintiff has its strongest case for defamation when these particular statements are read in isolation. With context, however, these statements are hyperbole, reflect poorly on the art of living, but do not amount to factual accusations of criminal activity, especially on blogs that readers obviously expect are critical of art of living. Courts have extended First Amendment protection to such statements in recognition that the reality of exaggeration and non-literal commentary have become part of an integral part of social discourse. By protecting speakers whose statements cannot reasonably be interpreted as allegations of facts, courts provide assurance that public debate will not suffer for lack of imaginative or expression or the rhetorical hyperbole, which have traditionally added much to the discourse of our nation. In addition, the blogs do link to the Art of Living website, and other articles about Art of Living are positively evincing a forum for debate and discussion. Now, interesting. In that one, they're saying that for debate and discussion, can anybody put an opposite view on? So it says, Paulson's speech is exactly the sort of commentary that must be protected under the First Amendment. Statements of financial dishonesty. These two are quintessential expressions of opinion. In McKee, the court emphasised that value judgments and rhetorical characterizations, even negative, do not become actionable merely because they sting. As in these cases, Paulson's reporting laid out facts, provided an opinion, and invited her audience the ability to make up their own minds, further underscoring that she was not presenting facts but analysis. No, she made her statements personal, and it wasn't one statement, it was probably more like 1,000 statements. See how now we've got contradicting a thing? Now she's saying, where has she said for her audience to make up their own mind? So I'm reading this and giving you my first thoughts of this, but I don't want you to take my what I'm saying as truth. I want you to do your own investigation and come up. If you've got evidence, for example, that she has asked for a debate on something, or she's given the other side of something, please let me know, because I'm interested, because I must have missed it. Allegations of control and financial coercion. Several statements in Exhibit A describe plaintiffs as exerting extreme control over dancers' finances, social media accounts, living arrangements, and personal relationships. Paulson's references to dancers being cut off to family, forced to tithe, or required to live communally were drawn from interviews and observed behaviour. When did she observe the behaviour? What behaviour did she observe? I mean, that's a very interesting statement. These statements are either true based on available public sources or are protected expressions of opinion drawn from observable patterns. For example, statements such as they control everything she does or they took over her bank accounts are not framed as factual declarations from secret sources, but rather are rhetorical syntheses of what Paulson and others could see or deduce. Where a speaker expresses a view about a pattern of control based on interviews, behaviour, or financial silence, courts routinely treat such assertions as opinion. Statements based on disclosed facts or interpretive summaries are protected. To the extent that statements reflect paraphrased allegations from public court filings or whistleblowers, they are not only substantially true, they are subject to fair reporting privilege. Mama Kay says that she watched their videos, that this filing is pure fiction. So yeah, they're trying to tell the judge, in my opinion, they're trying to tell the judge how she should be covering this. But anyway, statements summarizing lawsuits or quoting public records. Many of the statements at issue simply restate facts from public available lawsuits or interviews. Statements like a dancer sued 7M Films or this court filing alleges exploitation are not defamatory. She doesn't ever use the word, she very rarely uses the word alleged, sorry. If you'd like to show me postings where she does, please tell me. This court filing alleges exploitation are not defamatory. They are true. Even when paraphrased, they remain substantially accurate. And again, these statements are subject to fair reporting privilege. Sarcastic and hash-driven commentary. Paulson used hashtags like Free Miranda and 7M Cult to unify public conversation. Hashtags are a form of expressive shorthand. Courts recognise that hashtags are interpretive, not literal, and fall into the realm of online vernacular, not factual assertion. These examples, which span all major categories of contested statements, illustrate how Paulson's speech is protected by law. It's not enough for the plaintiffs to point to offence or injury. They must show falsity, verifiability, and factual assertion, which they cannot. The social media context only reinforces this process. In Johnson and Freeborn, the Minnesota Supreme Court emphasised that speech on platforms like YouTube and Twitter occurs in a cultural and expressive setting where exaggeration and commentary are norm. The court held that belief-orientated commentary, even critical, was protected opinion. Now, interesting, remember, she refers to herself as a digital journalist. So we get back down to, if everything that she writes, she's trying to state that everything that she's writing is opinion based on facts, right? But then do we get the definition of what a journalist is? Because doesn't a journalist report on fact unless they state that this is an opinion piece? So the court does not apply this four-factor test. Instead, it appears to defer to jury whether certain statements imply defamatory facts. That deferral skips the required gatekeeping steps. Court must make this determination as a matter of law. Plaintiff's implied defamation theory is illegally deficient. Plaintiffs argue that Paulson's speech takes in the aggregate, defaming them by implication, but implication is not a license to sue over tone or public reaction. It is a limited doctrine reserved for cases where specific verifiable facts are conveyed by juxtaposition or omission. That threshold is not met here, a legal standard. I don't like the font on this either. They usually don't like, well, in Australia, I can only talk about Australia, they don't like these fonts. They like the ones that makes it really hard to read. In Judwin, the court held the implication-based defamation requires identification of a provably false factual assertion. Vague insinuations are not actionable. Moreover, there is no claim for defamation where a false statement might be made from reporting of independently true facts. Application to the record. Plaintiffs identify no statements that, standing alone or in context, assert falsehoods. Instead, they rely to infer and audience interpretation. That approach is constitutionally insufficient. No jury can be asked to determine liability based on what a hypothetical viewer might conclude from otherwise protected expression. Mama Case says, and what journalist goes on lives and gets drunk and cuss out their viewers for their opinions? That's true. And who blocks their viewers for having a different opinion either? Don't forget that. I mean, anyone that had a difference of opinion got blocked. So is she given a forum where you can have a different opinion from her? Because this is what she's argued. This is her arguments. Plaintiffs have not shown actual malice by clear and convincing evidence. Defendants firmly believe that none of the statements alleged by plaintiffs to be defamatory meet the common law elements of defamation, even though most of the statements are about the plaintiffs, but not all of them, were communicated to someone other than the plaintiffs. They were either substantially true, non-reputationable, or a protected opinion under the First Amendment. She's going hard with this First Amendment opinion. Even if the statements might possibly be on their face defamatory, defendants allege that the statements were subject to a qualified privilege because plaintiffs are public figures. Do we determine that? I couldn't say Shin was a public figure. There's nothing about him on very hard to find information about him. They must meet the most exacting burden of civil law. Clear and convincing evidence of actual malice. The present record does not support such a finding. The proper malice standard is absolute malice. Okay. Because plaintiffs are concededly limited purpose public figures, speaking on matters of public concern, the First Amendment requires them to prove actual malice as defined in New York Times Co. versus Sullivan. That defendants publish challenged statements with knowledge of their falsity or with reckless disregard of truth. This is a constitutional, not common law standard, and it demands proof of defendant's subjective state of mind, evidence that the speaker actually knew the statements were false, or, in fact, entertained serious doubts as to the truth of the publication. Now, I've always maintained that I have thought, hi, Vidandra, I have always maintained that I have thought that Katie's statements were made with a reckless disregard for the truth or for clicks and views. Because she knew that certain statements would actually get clicks and views and therefore generate further income, which comes to a reckless disregard of the truth. Okay, but they're saying that yeah, I mean that is a standard of malice, as we said, actual malice. So it says negligence, motive, hostility, or failure to investigate are not enough. This heightened requirement applies regardless of whether a defendant is a journalist, blogger, activist, or private citizen. This dispositive question is for plaintiff status and subject matter of the speech. Here, the plaintiff's own concession that they are public figures and the undisputed fact that the speech concerns matters of public concern. The Supreme Court has consistently rejected any distinction between press and non-press speakers when applying the Sullivan Rule. See Gertz versus Robert Welsh. Minnesota court follows the same approach, focusing the actual malice inquiry solely on whether the plaintiff is a public figure and whether the speech addressed is a matter of public concern. Thus, the only constitutional permissible standard is the New York standard, actual malice standard. So, to demonstrate actual malice, the plaintiff must show that the defendant published a statement with knowledge or falsity or reckless disregard of the truth. Mere negligence or bias is not enough, nor is ill will. The defendant must subjectively know the statement was false. The court must also determine whether there is evidence of such malice as a matter of law. What is not evidence of malice is a long list, highly slanted perspective, motive to harm, or failure to investigate a source's credibility or fall short. The court's discussion of malice appears to have treated all the factors such as ill will, contentiousness, and parties' history as potentially sufficient to create a jury question. Those factors, while perhaps relevant to other contexts, do not establish constitutional actual malice for public figure plaintiffs. They're dying on this public figure hill, aren't they? The proper inquiry is whether there is clear and convincing evidence that Paulson subjectively knew her statements were false or seriously doubted them at the time of publication. What are your thoughts on that? Here, Paulson, application. So here, Paulson relied on interviews, documents, court filings, and visual observations. Again, I want to know how she observed. What has she observed? She repeatedly expressed her belief in the truth of her statements and encouraged her audience to make their own judgments. Again, if somebody can show me, where she has encouraged her audience to make their own judgments, please, I'm interested, because I must have missed those again. In McKee, the Minnesota Supreme Court noted that even repeated criticism and harsh language cannot substitute for actual malice. The US Supreme Court held that courts must conduct an independent review of the record to determine whether actual malice is met. Plaintiffs have not presented evidence from which a reasonable jury could find that Paulson acted with knowing or reckless falsity. In fact, defendants have not presented evidence of any factual statement as false. So then there's a footnote. The single false statement that Paulson acknowledges is that Miranda and James Derrick may not have been married. However, this claim was based on questions raised by the Wilkins, was framed in the post as being based on the Wilkins concern, and was supported by facts that indicated that other 7 named dancers were presenting themselves as being married when they were married to other individuals. Paulson stated that she searched public records to determine if their marriage certificate had been filed. In fact, until the Derricks produced their marriage certificate in this litigation, Paulson had no basis to believe that she was incorrect. More importantly, plaintiffs produced no evidence suggesting that her statement was untrue or that she should have known the statement was untrue. Even if the court takes Paulson's acknowledgement of her error as evidence supporting actual malice, it is still not defamation, because the plaintiffs have not alleged any reputational harm resulting from the statement, and it cannot support a claim of negligence per se, as there was nothing illegal or wrong about not being married. And so here's the question. If she's made one mistake, right, could she have made more? The court's gatekeeping wrong. The order notes that the plaintiffs disputed the truth of Paulson's statement at deposition and views this as a jury question. Respectfully, under controlling precedent, disputed truth alone is not actual malice. Only evidence of the speaker's subjective doubt can suffice. Where the record is devoid of such evidence, summary judgment is required. This case does not involve backroom sabotage or private meddling. It involves public advocacy. Paulson called for viewers to stop supporting 7M films and affiliated ventures. A form of expression in the United States Supreme Court has held to be constitutionally protected. A claim of tortious interference cannot be predicted or predicated on speech that is itself protected by the First Amendment. Allowing plaintiffs' claim to proceed despite this expressive conduct risks punishing protected speech through backdoor tort law. To prevail on a claim of tortious interference with prospective economic advantage, a plaintiff must prove that the defendant's interference was not justified. When the alleged interference consists of expressive conduct on a matter of public concern, the justification is rooted in the First Amendment and must be resolved as a matter of law. The Supreme Court in NAACP versus Claiborne Hardware held that public boycott advocacy, even if it causes economic harm to its target, constitutes protected political speech. Absent violence, threats, or unlawful conduct, the loss of business must be borne by those who suffer it as a consequence of constitutionally protected expression. Minnesota courts likewise recognize that even economically damaging criticism about matters of public concern cannot give rise to liability, absence of unprotected conduct. Dismissing tortious interference claim where speech was protected by the First Amendment. Okay, so here's my question. Does the phrase internet do your thing? Let's see. application to the record. Let's see what she says about that. Paulson did not threaten, coerce, or act secretly. She publicly posted videos encouraging consumers to stop supporting plaintiffs, explaining her reasons and sharing her personal reactions, legal information, and commentary. Her speech was directed to an audience concerned about matters of public interest and urged lawful, non-violent consumer action. This is precisely the type of advocacy Claiborne Hardware shields from tort liability, even if it causes economic harm to the target. The Minnesota Court of Appeals decision in Moore versus Hoff is instructive. There, as here, the defendant used an online platform to criticize a public figure and used an urged public-based. Hang on. Hasn't she denied doing that? Hasn't she denied the whole Clippers thing? Now she's saying that she's done it. Here, the defendant used an online platform to criticize a public figure and urge public action based on alleged misconduct. The court held that speech was protected because it addressed a matter of public opinion, which did not fall within unprotected category. Plaintiffs cannot repackage their disagreement with Paulson's message as interference without colliding with core First Amendment principles. Hang on a minute. Remember, she did that whole video about how she showed proof that she was sent, that somebody else had contacted the Clippers and it wasn't her and she had never done it. And now she's saying she did do it. Right? Right? So, okay. Because interference alleged here is inseparable from Paulson's protected speech, the claim is barred as a matter of law. Tort liability cannot be imposed for engaging in constitutionally protected expression of matters of public concern. I just hope the judge may need a stiff drink after trying to sort this out. This is like, as I said, I'm sure that she had said she did a whole video about the Clippers, or she did a whole Instagram rant on the fact that it was somebody else and that was she'd never done it. And now she's putting in another motion that she did do it. But it's okay. It's protected by the First Amendment. Wow. Okay. We're at page 18 of 23, and the next one is 64 pages. So I hope you've got all night. I started early for this reason. In State versus Turner, the Minnesota Court of Appeals held that Minnesota statute was financially unconstitutional to its overbreadth and lack of scientific requirement. Though the legislature amended the statute in 2016, the Minnesota Appellate Court has held that this amendment rendered the statute constitutionally sound. The Turner Court's concerns were not limited to the absence of the, I'm sorry, I cannot pronounce this word. Ask AI's assistant to pronounce it. How to pronounce? Cinta? I apologize, okay? Yeah, okay. That's all right. Okay. They also forced the statute still in effect and potential to encompass the protected speech. Most importantly, the court held that it would be unconstitutional to convict a person for violation of the statute without finding actual malice. So even if there was an amendment to the statute which included the Cinta element, its application would not be constitutional here because the plaintiffs have presented no evidence of actual malice. So just so that you know, Psi is pronounced as S-I-G-H and the end as in end and ter as in. So to pronounce it, the S-C-I is pronounced like Psi. The E-N is pronounced as end and the T-E-R as in turkey. Scienter. And it refers to the mental state of a person indicating that they acted with knowledge of the illegality or with reckless disregard of the truth. It is a key element in proving fraud or other intentional wrongdoing. That's what it means. Okay, so it's scienter. Just right, so we've got it. So assuming arguendo that the plaintiff had presented evidence of actual malice, an instruction on the issue of negligence per se would be unconstitutional, since the language of the statute would be inserted in the jury instructions conflicts with the actual malice instructions. So then you've got here the statute. Defamatory matter is anything which exposes a person or group or class or association to hatred, contempt, ridicule, degradation, or disgrace in society, or injury to business or occupation. Acts constituting whoever, with the knowledge of its false and defamatory character, orally, in writing, or by other means, communicate any false and defamatory matter to a third person without consent of the person defamed, is guilty of a criminal defamation and may be sentenced to imprisonment of not more than 364 days or to a payment of fine of not more than $3,000 or both. And then justification, the communication is privileged. The communication consists of fair comment made in good faith with respect to persons participating in public concern. The communication consists of fair and true report of a fair summary of any judicial, legislative, or other public or official proceedings. So the communication between persons, each having an interest of duty with respect to the subject matter of the communication, and is made with intent to further interest or duty. In contrast, actual malice, must be proved by clear and convincing evidence that the alleged defamatory statement or communication was published with actual malice. The definition of actual malice: a statement or communication is published with actual malice if the person who published it knew it was false or had serious doubts about its truth. Clear and convincing evidence means it is highly probable that the statement was published with actual malice. Put it in another way, you must firmly believe that the defendant published the statement or the communication with actual malice. And they're saying that it would, the jury would reach an inconsistent verdict. Defendants are not necessarily arguing that a person cannot be charged for violation of Minnesota Statute 609, although there is a strong argument that this statute will still trends uncomfortably close to a violation of First Amendment rights. However, the question here is slightly different. In a civil case, may this statute form be a basis for negligence per se? The answer must be no. As a practical matter, the inclusion of this cause of action does not create any substantial rights for the plaintiffs, because if Turner requires a finding of actual malice and the court and then the jury concludes that actual malice exists, then there would be a liability for defamation. Plaintiffs who refuse to produce damages discovery despite a court order. While constitutional issues are dispositive, this case also presents a more procedural but equally seriously problem. Plaintiffs have not produced discovery supporting the very damages they claim to justify. Despite being ordered to do so, they've failed to provide tax returns, balance sheets, monetization records, or any other financial documents. Their failing makes meaningful defense and meaningful trial. They're still dying on this hill. We saw what was ordered for discovery, and they're still trying to get stuff that was not ordered in discovery. Under Minnesota law, courts may impose sanctions, including exclusion of evidence or dismissal where a party fails to a discovery order. This is standard, not that the failure was malicious, but whether it was willful, prejudicial, or without excuse. In Frontier Insurance Co. versus Frontline Processing Corp., the court barred all damages testimony where the plaintiff failed to produce supporting records. There are a whole host of non-published opinions that make it clear that this non-controversial rule of law whether a court has properly imposed discovery sanctions is determined by examining the following four factors. If the court set a date certain by which compliance was required, the court gave warning of potential sanctions of non-compliance, if the failure to cooperate with discovery was isolated event or in part a pattern, if the failure to comply was willful or without justification, and if the moving party has demonstrated prejudice. The court's order dated January 29, 2024, unequivocally stated that financial discovery should be provided. Defendants acknowledged that this order did not provide a date certain or provide a warning for non-compliance. Moreover, defendants acknowledged that the imposition of discovery sanctions are within the discretion of the court. However, this is a case where plaintiffs are asking for millions of dollars, and yet they provided no meaningful financial discovery. The court's summary judgment order declined to impose sanctions requested by the defendants, but defendants should not be required to bring a separate motion in order to obtain the necessary order requiring plaintiffs to provide discovery by a certain date, with a warning that failure to comply may result in dismissal of claims. Such a result would be the fourth time and the fifth hearing where defendants have sought the court's assistance in obtaining this discovery, which is essential to the defendant's defence. So this is what they want from the court. They respectfully request the court grant reconsideration of its June 24, 2024 order, enter summary judgment in defendant's favour on all remaining claims. In the alternative, impose sanctions for plaintiff's refusal to produce court-ordered discovery. Dismiss court 10 as unsupported by valid legal standard. Grant such other and further relief as the court seems appropriate. Why this case matters. This is not a motion about correcting an oversight or reasserting control over discovery. It is about reaffirming the constitutional limits of tort law. When the court allows the case to proceed based on insinuation rather than evidence, implication rather than factual assertion, or public offence rather than legal injury, it transforms trial into punishment and chills speech by design. I don't like that phrase, chills speech. Who writes chills speech? It transforms trial into punishment and chills speech by design. Cold as ice. If Paulson, a solo journalist operating independently on popular platforms designed for expressive, provocative engagement, can be put to trial without a showing of falsity, malice, or actual damage, then so can anyone who comments on powerful interests. This is not the law. It is not consistent with Minnesota precedent and is not consistent with the First Amendment. The court's responsibility is not merely procedural, it is constitutional. Defendant respectfully requests that the court reassert that role here. First Amendment requires that before public figure plaintiffs may proceed to trial on claims arising from speech. Mama Kay says she was not implying. That was my interpretation as well, Mama Kay. But you need to make up your own. You need to make up your own mind. The court must decide the three threshold questions of law: whether the challenge statements are actionable fact or protected opinion, whether in the implication claim conveys a provable false factual meaning, and whether the record contains clear and convincing evidence of New York Times actual malice. Plaintiffs concede they are limited purpose public figures and the speech at issue is unquestionably on matters of public concern. None of the constitutional prerequisites are satisfied here. The statements are non-actionable opinion or based on disclosed facts. So this is her hill. She's saying they're non-actionable opinion or undisclosed facts. No implication claim meets the narrow standard. There is no clear convincing evidence of actual malice. For the same reasons, plaintiff's tortious interference claim fails because it is predicated entirely on constitutionally protected advocacy. The negligence per se claim under Minnesota statute is foreclosed by Turner. Even if the courts were to disagree on the merits, plaintiff's failure to comply with court's damages discovery order provides an independent basis for dismissal or the narrowing of claims. Respectfully, the court should grant reconsideration, apply the constitutionally mandated standards, and enter judgment for defendants on all remaining counts. The undersigned acknowledges that cost disbursements and reasonable attorney and witness fees may be awarded as per the statute, and that has got Jennifer Moore's signature on it. That is their case. Now, there is a third document, which is an affidavit. So that, to me, that document was contained a whole lot of hyperbole. So where she said, we're not submitting any new evidence. on this matter, but we're not going to submit any new evidence on this matter, but we are submitting the fact that he was raided. Well, that's new evidence. You know? So this is her sixth declaration that she's an attorney licensed to practice in the state of Minnesota and one of the attorneys on record for Catherine Paulson and with our crystal ball. In preparing the accompanying filing, she searched and obtained judicial opinions and articles identified from reputable and publicly identifiable sources. So she's got Hunter and Coughlin. She's submitted Albert and Chong Xing and Denny and Denny. Then she's got Exhibit 6 is Dooley and Ross. Exhibit E is Art of Living Found. So these are the cases that she's referred to. And F is an exhibit of copy of Los Angeles Times article of the TikTok cult being raided. He's investigated, and from July 2025. Remember, it said in their document that they weren't relying on any new claims. So this is, so there is a thing that you do. So this is download. So this tells you what they've got it from. Hunter versus Coughlin. It always gives you a decision date, the docket number, citations, and then there's a link there. And then this is, I tell you what, these are actually very, in my opinion, these are very hard to read. The Australian ones are a lot easier to read, in my opinion. Then that's my opinion. Okay, that's my opinion. The judge can reject it. I'm interested that it goes to the same judge. That's what fascinates me, because you're asking the judge to reconsider a decision that they've already made. Now, if they've already, I don't understand how you can actually trying to change somebody's opinion. Now, often whenever you do those in Australia, any appeal is always done by a different judge, because they remove the person that made the first decision and they take it to a different decision, a different judge, to have a set of fresh eyes look over the case. And the judge will either come back and say, yes, there is something that needs to be, there is a possibility the judge has made an error. They've interpreted it this way, but we think it should be interpreted this way, which is still very subjective. But it's always seen by a different judge. I find it very fascinating that it goes back to the same judge. It would be like me asking my mum for something and my mum saying no, and then me going to my dad to ask the same question, and he says, well, go ask your mum again. Well, you know that your mum's already said no. What argument are you going to give your mum to get her to change her mind if she's already made that decision? That's what I find fascinating. So these are the save trees. So this is Exhibit A. So this is Art of Living. If I had time, I'd read these and give you my. So what often it will give you is a very quick. So you sometimes get a pretty quick summary here. Like this first bit is generally the short summary. Then you get the background of the case, and then you get both sides. So when they do a decision, they always. I did hear that, but here's the thing, Mama Kay. She will say it's a matter of opinion, but I did notice that people had said that they had written complaining about the judge. If you've got people doing stuff, does that mean that they're taking what you're saying as truth? So they always give both sides, right? Arguments on both sides, and they will give the legal summary, and then they will come up with usually they'll come up with a decision and tell you how they got about their decision and why they feel about their decision. So actually she's only just done this because this was downloaded on the 14th of so, and then she's got this one. Exhibit F. So we're not relying on new evidence, but we're relying on new evidence. So yeah, so that's what they've put in. Because if I said to you, you all need to, we need to write to Judge Willis, and you will then go to Judge Willis and you like hounded her, that would be because you thought that what I was saying was believable, or okay, you're taking action on something that I've said. But if I would say to you, you need to always do your own fact-finding mission. And that's why I say to you sometimes, didn't she say XYZ? Because I'm then relying on my memory, and I remember her saying, posting something on social media, and now there's something else in a court filing, or I'm suddenly remembering something she previously said in a court filing, or I'm remembering what the judge has said, because I do take notes and I have my notes in front of me as well. So I tend to try and ask questions, but I want you to challenge me if you think that what I'm saying, maybe wrong. But anything that I do say, and remember, I'm only a law student, and it is just my opinion. And I live in Australia, and we do things differently in Australia. We would never ask for a reconsideration. We would just appeal. You have to ask the court to do it. It's actually, it's generally expected for you to appeal. Most decisions are appealed if there is if they think that there is a chance that they can do it. You remember it like I do, that's good enough. Okay, so we've got the same memory. So that is it. Yeah, I've been seeing some stuff that's been posted by her, but yeah, so we now wait. I think we now just have to wait now for the other part side to file theirs. I think they've got 14 days. I think was it 28 days, 14? Usually it's 28 days, 14. So we'll see what happens with that. But in my view, there was a lot of hyperbole and a lot of backtracking. And as I said, quite a few contradictory statements. Appreciate you breaking it down. You have more knowledge of the law than KJ does. Well, I mean, that's what I'm studying. She'd have more knowledge of Spanish than what I do, presumably. But I noticed also, if you notice, that she talked about being an online journalist at one point. She talked about being a digital creator another time. Then she talked about being a journalist. And where she talks about the fact that she's and then like her YouTube channel says that she's a tea and commentary channel. That's a different kettle of fish again. So she keeps changing who she wants to be. She wants to be a journalist to get this protection of journalisticness, but then on the other hand, she's put in her motion that her channel is, her people come for the tea. Well, that's gossip. That's gossip. Then that is not. Then why, so again, there's so much that is contradictory in that document that it's giving me a headache. So on that note, I'm going to head off. Look, I hope to come on again soon. Thank you for joining me. I'll definitely keep an eye on this for you, and wait for the next of the filings to come out. And I will catch you. Her occupation changes to suit the situation and her narrative. Yes, journalists don't get online. Well, and that is also true. And I mean, if you look at even the online media and stuff, they always put this is an opinion piece. This is an opinion piece. So you know that what's going to be said is just someone's opinion, right? But generally, journalists, they report what's happening. And generally, you take it. Remember the days when you used to watch the news and you could believe everything that was said because what they reported were facts? You know, there was a fire at XYZ. The fire was suspicious. Everybody got out. The fire was put out at such and such a time. And you could go, wow, there was a fire there. Wow, it's good everyone got out. That's right. And journalists stay neutral, and they also give both sides of the story. I was talking about this to somebody who was writing the book, and they're talking about a major company, a major entity in Australia. And I said to them, and I said to them, speak to a lawyer, but the lawyer actually confirmed what I said, which was what you need to do is you need to write that in the start of that chapter that this is based on their version of events and that they've reached out to other people involved in this story and they've declined. So often you'll see this masthead reached out to XYZ and they for a statement and they declined. And so what they're saying is that we have reached out to get the other side of the story, but they've declined to cooperate. And that's how you do it. And so this person's writing the book and is really concerned about defamation because, but again, it's their version of events. But they've reached out to some of the people that are going to be mentioned in the book, or people that aren't named, that when they read it, they'll know it was about them. He's reached out to them and they've said, well, we're not going to give you a comment. And I said, well, you've tried. So now they cannot complain that they're being shown in a bad light because you've asked them for their version of events. And so he could put his side forward and say, well, so-and-so believes XY, says this is how it happened. And, you could put in the book both sides and then you let the readers, they used to give both sides of the story and then you are left to make up your own mind. And that's really what that's really what I want you to do. But we've gone through the court filings. You can see them for yourself. As I said, as I read, there's some, to use the word chill, to chill freedom of speech. I've never heard. It's just I wouldn't use it. So apparently it's called a chilling effect. Exerting this chilling effect. Yeah, as I said, I wouldn't necessarily use it. So the chilling effect in law is the inhibition or discouragement of the legitimate exercise of natural or legit rights by the threat of legal sanction. As I said, I just don't like it. And I guess again that is, and again it might be because I'm from Australia. We chill in Australia means to calm down. If we were going to say that, hi, short order. If we were to say about chill the language, it would be toned down. Or they're very relaxed or easygoing. That's what it means for us. Not worried about anything. So when you're talking about being chilled or talking about chilling freedom of speech, it's as I said, it's a language thing. So that's why I'm saying I wouldn't use the word chill, freedom of speech in a sentence, because what you're saying is that relaxed or easygoing, So yeah, it's very, very interesting. So it's the same over there. Yeah. As I said, I don't. Yeah, to me, it just sounded uncouth. Can I use the word? But it's slang. Yeah, that's right. Yeah, so chill means calm down, or let's chill means let's hang out and just chilling, relaxing. So it means, yeah, as I said, I wouldn't use it in a legal document for a turn of phrase, but anyway. The other word, I think the other phrase that they use is, we're getting off topic here. Calm your farm. It's called calm your farm. Uncouth. I know. I'm very impressed I used the word uncouth. I couldn't think of it. Uncouth was the first thing that jumped into my head. Uncouth. So calm your farm is an Australian slang term that means to relax or calm down. It's casual way of telling someone to take it easy, not to get worked up. So, for example, you might say, calm your farm, everything will be all right, or calm your farm, we have plenty of time, or take a chill pill, calm your farm, take a chill pill. So, yeah, so it's, yeah, so that's really what, and so when I see about, the chill, this could chill freedom of speech, I just go, oh yeah, that's going to relax. Like they're saying it's going to, so yeah, it's weird. So yeah. Calm your farm. Oh dear. It's a wonder they didn't add a Netflix. Oh look, I've just clicked on this link. Australian slang terms every visitor should know. Let's just before I finish up, let's just get ourselves, let's just educate the wider world on this. This was from CNN in 2024 August, nearly a year ago, that they published. Australian slang term everyone should know. So, do you know your yeah nah from your yeah nah yeah, or your whoop whoop from your wig out? Australians have prided themselves on putting their own twists on the English language. When they say, can you speak more than one language? I go, yes, I can speak Australian and I can speak English. Actually, maybe three. I can speak Australian, I can speak Bogan, and I can speak English. Okay. So there is an Australian National Dictionary. So here we go. So have a yarn. A yarn in Australia is another word for chat. So to have a yarn is simply to have a chat. A yarn on its own is a story. For example, someone might say, have a yarn with you. Hard yakka means hard work or strenuous labour. The word was first derived from Yaga, which means work in the Yagara language, the traditional language of the Yagara people who live around the area which is known as Brisbane. So hard yakka. Yeah, nah. Aussies love to use yeah as a word before continuing their train of thought, but it gets a little confusing when you're trying to work out if someone's saying yes or no. So, yeah, nah simply means no. Are you coming to the beach today? Yeah, nah, don't think so. Far out is a phrase to express frustration at a situation. Sometimes it's also used as far out Brussels sprout. Far out Brussels sprout. Isn't there another line to that? Whoop whoop. This phrase Aussies use to describe a place very far from them. It's usually remote, and sometimes the word insinuates it's a backward place too. They're living out in whoop whoop. To have a head noise, that's what many young Aussies say if they're feeling a bit anxious, or if you're really overthinking the situation, they'd say you are noisy. Put a sock in it, it simply means to shut up, but in true Aussie culture, it's not particularly offensive. Put a sock in it. Tell him he's dreaming. This phrase comes from a classic Australian film called The Castle. If you've not seen it, you need to. Where the main character, Dale Carrigan, fights for his home as the bank tries to buy it to build a new airport expansion. Every time Carrigan made an offer, he simply has a simple defense for his home. Tell him he's dreaming. Now the expression has seeped into the Australian culture and is used in response to a seemingly outrageous task. Crack the you-know-whats. It means to get really mad at a situation. That's pretty much of saying having a tantrum. The ant's pants. If someone's the ant's pants, they're the best. The battler is somebody who pushes through when things are tough. Yeah, to calm your farm. Whoop whoop. If you can't remember the name of the town or can't pronounce it, that's right. There's a few of those towns you can't pronounce. So you go, or if you don't remember where you went to and you just go, up, whoop, whoop, somewhere. Calm your farm. Flat out like a lizard drinking. Working hard as you can on the particular job. For example, someone calls out while you're at work, you might say, can't talk, I'm flat out like a lizard drinking. No wuckers, no worries. She'll be right. She'll be right essentially means it's all going well. Bogan is an uncultured or unsophisticated person. It used to be an insult, but it recently became more widely used in contexts that are neither derogatory or negative. Some people actually love being called bogan. To do a Bradbury, for those of you who don't know, Stephen Bradbury actually won the 2002 speed skating gold medal because everybody else fell down around him. So it says, at the 2002 Winter Games, Stephen Bradbury tailed at the back of the group of the men's 1,000 metres short track speed skating final when all of a sudden the leader of the group fell, taking out other athletes in the front of the pack with him. Bradbury, with a sizable gap at the back, shot through the pack and won gold, becoming Australia's first ever Winter Olympics champion. The moment is now infamous. Cultural moment to Australians, so the expression do a Bradbury is now used when someone unexpectedly succeeds at something they don't expect to. Have a sook is what is used when someone doesn't get their way and is down or upset about it. So to have a sook is to be in a bad mood. Sometimes Aussies will say that the person is being a sookie la, meaning that they're staying in a bad mood. Sookie la, sookie la. A chook is a chicken. I didn't come down in the last shower. And meaning to say we're not stupid. And the thing Aussies love to do is to chuck an O or an IE on the end of abbreviated words. So servo is simply a gas station. Ambo is an ambulance officer. A bottle-o is where you buy alcohol from. Arvo is afternoon. And an avo is an avocado. Oh, there's not much there. Steve is Steve-o. Super sook, a big tantrum. What else? So then we have Macca's, which is McDonald's. Yeah, Arvo. Yeah. Alco. Alco is brekkie is breakfast. Yeah. University becomes uni, and a U-turn becomes a Yui. A barbecue is a Barbie. A cigarette is a durry or da or ciggy. A utility truck is called a ute. Kangaroo is a roo. A sandwich is a sanger. So sometimes you'll say, what have you got? What have you got for lunch? I've got a sanger, salad sanger. Devastated can be called Devo. Did you know that the word selfie came from Australia? So there's lots of different words that we do because we're fun. Aggro is aggressive. A biffo, it's a fight. A biffo is a fight. A reno is a renovation, doing a home reno. Compo is compensation. Defo, definitely. Doco is a documentary. A garbo is a garbage truck or garbage man. Hospo, hospitality. A journo, a journalist. A mo is a mustache. A muso, musician. Prego, so is somebody that's pregnant. Prego. Rego, car registration. Relo, a relative. See, we've got it. Salvos is the Salvation Army. Smoko is a break. A typo is a typing error. Vego is a vegetarian. So yeah, so there you go. There's some words. So just to make you understanding. But yeah, chill. As I said, chill for me. Whenever I see that word chill, I read it as relaxed. So that's why I've had trouble with the line in that document about it could chill freedom of speech, because yeah, it just does not seem right in that context, in that formal. Because remember, a legal document needs to be formal. You need to use what's drilling to us is that we've got to use formal language. There's no way we can put these abbreviations into our legal documents unless you are quoting a witness, or unless you are quoting from a judgment where a judge has referred to it. It's the same with swearing. It's the same with language. You just can't do it unless it's being referred to in a document and then it's quoted. It's always in quote marks. But yeah. Anyway, thank you for joining me. As I said, I will hopefully catch you again later. There is a video that's gone up for all the members. Harrison, my nephew, you may know, he got to do it. He did an interview, which is now on he got to interview a local AFL coach. And so I've put it up there for members. It will go live later on. So if you're a member, you can watch that first and give him some feedback, encouragement. He's 14 now, so getting old. Anyway, so I said, thank you for joining me. That's where we stand with the legal filings. So now we just have to wait for 7Ms. And I also noticed that it was very interesting that they've talked about Shekinah Church again. Remember, Shekinah Church is not a party. So here's where it gets to me. There's a grey area. If there's stuff about a party that's not mentioned, then they're not party to proceedings, then it could be said that anything that's referred to them. Oh, yeah, that's right. A sickie is a day off when you're sick. A sicko is a person a bit psycho, and a psycho is just a sicko. That's right, Shorter. A sickie. Yes, and we use chuck a sickie. Chuck a sickie. To chuck a sickie is to take a day off when you're not really sick, but because you got your sick leave up. I think I've actually got more sick days than I have annual leave days at the moment. So you chuck a sickie. But yeah, it's very interesting to see how the judge is going to handle the fact that there was some comments made that relate to the church but don't relate to 7M. And because Katie Joy sort of uses them interchangeably, if something that's directed or meant for the church is directed at 7M, therefore is that deemed defamatory to 7M but not the church? See how it's a very grey. We've got a very grey area here. So if she's talking about the church being controlling, but she's used that to refer to 7M, but she's really talking about the church, but because she hasn't specified that it's church, and it's because she hasn't specified that it's the church and it's been put towards 7M, yeah, then it's defamatory. Hello, Bella Marie. You've been a member for 28 months. Wow. Thank you. Yeah. So that's where we get into it. That's where we get into a big grey area. Huge grey area. And I don't know the answer to that. I don't have the qualification or the skill to try and work that out. Above my pay grade, and I think it could possibly cause for me it would cause the judge a headache trying to work out. She shouldn't be talking about either. If you ask me, look, I don't think she should be either. It is, it's my opinion that she should be laying low or talking. If she's going to do it, you need to be making sure that you're talking facts, that what you've got you can back up factually. So that's my view of it all. That's my opinion of it. And see, she admitted that she made a mistake with the marriage thing, and that the marriage certificate, as soon as it was proven, she corrected it. Well, then if she's already made one mistake, what other mistakes has she made? And if making those mistakes, so for example, 7M, well, it's like they're saying they haven't seen any proof that there's any damages for 7M. Well, 7M as a company no longer exists. So if it existed before and it no longer exists now, do you call that harm? And how do you put a cost of that? I'm doing all right, Bella Marie. Some very interesting questions that I think the judge has to try and work out. To say, she's probably, that would be the only thing she's corrected. Yes. But she also used, don't forget that she read from a court document where a settlement had occurred. Okay. You can read from the document, but that's fine. But you can't make basis or, I can't go back and read her Todd Chrisley stuff and say, oh, this happened because they settled. Okay. So we don't know. We don't know what was true and what wasn't. But we've got her version of events and Todd Chrisley's version of events. And so we can make up our own minds whether what she said was defamatory or whether who's defamed who or whatever. But because it was settled, they both, took certain actions. She certainly shouldn't be talking on MSN, mainstream media. Why isn't this interference? She has a jury trial happening and it's like jury tampering. It is. But we've just read her motion for reconsideration. Short order. I thought it's very interesting that they're going back to the judge that made the decision. and they're putting forth arguments as to why the judge should change her mind. And I find that bizarre because, as I said, I use the analogy of a parent, right? If you go to your mum, like if you went to mum and said something and your mum made a decision, and then you went to your dad and you put your case to your dad and your dad says, well, you've got to go to your mum. Like, most of us know that if mum's already made up her mind, right, then she's not likely to change it. But you're going to the judge with a whole series of facts and saying you're wrong because of X, Y, Z. I find that fascinating that the same judge gets it. I guess there's a reason for it. Where in Australia, it goes to a different judge. They read everything that's gone before. They read the judge's decision. They hear the arguments, the new arguments as to why, it should be overturned, etc., 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 and then makes a decision based on all of this other stuff. And they'll say, yes, they did get it wrong because we've interpreted it the way that you've interpreted it, which is different to this judge. We're not saying the judge is wrong. We're just saying that their interpretation of the law, we think that, wasn't correct in this matter. It's also an attempt to get accreditation being a journalist when in fact she's a content creator with a grudge. Well, she refers to herself as a digital journalist. Yeah. So I go through it all, and I think we've got 3 or 4 different job titles in the one document. We're not relying on any new evidence, but we're gonna slot in here that Shin was raided. We're gonna slot that in there, and see we were right because we said these were allegations. And she's trying to get the search warrants because she wants to know whether she's right or not. And she could be. I mean, here's the thing: she's made all these insinuations that it was about trafficking and all of this other stuff, when in fact, I still think it's to do with tax issues, which just because he's raided for tax issues doesn't mean that he's guilty of everything else, or just because he's guilty of something doesn't mean that he's, I mean, he could be guilty of it all, right? But that's not for me to insinuate because we don't know. And the fact that there's been no arrests is another reason why I'm thinking it's more to do with tax or immigration rather than all this other stuff that's been implicated. But anyway. Anyway, as I said, this is my 3rd attempt at going. I better go before I stay on all night. I've got to do some other stuff. But yeah, I'll catch you all later. And thank you for watching. And as I said, make sure you hit like and subscribe. And I'll see you next time. Bye for now.